Let's get started for our Manatee Awareness Month webinar. Thank you everybody for joining. My name is Cora Bircham. I'm the Director of Multimedia and Manatee Research Associate with the Save the Manatee Club, and I'm also joined here by my coworker Alex Russell. She is our Director of Web Development, and then of course by our Director of Law and Policy, Environmental Law and Policy, sorry, Elizabeth Neville, who will be giving a presentation today. Very exciting. This is the first time that we're doing this on manatee laws and manatee law school. So just want to take a quick moment to introduce Elizabeth. She just joined our organization a couple of weeks ago as our Director of Environmental Law and Policy. She has a Bachelor of Arts in English from Pepperdine University and has done an internship with Save the Manatee Club back in the day. And after graduating from the University of Colorado Law School and completing her judicial clerkship in the Virgin Islands, she returned to Florida where she opened her own law practice. And SMC was actually her first environmental nonprofit client. Now, after practicing law for 9 years and working with numerous environmental organizations, she joined our staff a few weeks ago, and we are really excited to have her and all of her knowledge. So very excited for this presentation. Just a couple of housekeeping rules for everybody. We will be hearing the presentation first, and then we will be taking questions from you. So you can put those questions in the chat or in the Q&A box here on Teams, and then we will be passing them over to Elizabeth to answer them. This session is being recorded, and we will be putting this on our website afterwards. So in case you want to rewatch it or you're not able to watch it live, you can then also rewatch it later on. And with that, I will hand it over to Elizabeth.
Cora, thank you so much for that kind introduction, and thank you all so much for being here. I have loved manatees my whole life, and a desire to work in manatee conservation is a lot of what drove me to pursue this career path. So it's just really an honor to be in a virtual space with a group of people who also care about manatees. So let's get started. So here's a very quick overview of what we'll be discussing today. We don't have a ton of time, so this is going to be very high level. And if you are not an attorney, don't have legal background, that is okay. This is really the very foundations and basics of some of the laws that are really critical to manatee protection. This, of course, isn't everything. There are practitioners that dedicate nearly their whole careers to just the Endangered Species Act, for example. But I'm hoping this will give you a good overview of what legal and policy advocacy for manatee conservation looks like. So we're going to first talk about federal laws, then state laws. These are laws applicable in the state of Florida. Then some recent developments under the Endangered Species Act and Marine Mammal Protection Act. They're all proposals. None of them are, a sure thing as of now. And then I'm going to describe a couple of cases that are in ongoing litigation. And I do just want to note at the forefront. So Save the Manatee Club is a plaintiff in the DOA case we'll be talking about. That's the Department of Administrative Hearings. And I'm going to warn now that to be an attorney is to live in alphabet soup. There are so many acronyms all the time. I'll do my best to break them down. And the second one, though, the Bear Warriors case, we are not a party to that case. We have submitted a friend of the court brief about Endangered Species Act interpretation with other colleagues, but I just want to be clear, we are not the plaintiffs in the Bear Warrior case. And then finally, we're going to talk about how you can take action for manatees. So some quick background on our modern environmental laws. In the 1960s and 1970s, there was a very much a growing environmental awareness and growing media attention to environmental issues. Having television wider spread helped people really understand things that otherwise were just hidden in obscurity. For example, the Cuyahoga River caught fire many times in the late 1960s, and one fire in particular where an oil slick ignited, you can see that photo there, received massive media attention and helped spur the passage of the Federal Clean Water Act. And then on the right, I have a copy of Silent Spring by Rachel Carson, published in 1962, that talks about ecosystem collapse from DDT in particular. And not only was this a book that changed my life, my high school ocean sciences teacher had us all read this, and it really kind of catalyzed my own career path. This was a national phenomenon. If you do some searching on the internet, there were a bunch of Peanuts comics. Lucy, the character in Peanuts, loved Silent Spring, loved Rachel Carson. So just some background on why all of the laws we're going to talk about were passed in the 60s and 70s. And there are a couple of basic structures in all of the environmental laws we're going to talk about today. So essentially, they will put forth prohibitions on harmful activities such as pollution discharge or take of animals. And we're going to talk about what take means. It comes up a lot. But then they create permitting structures for people and entities to gain permission to undertake or risk undertaking these otherwise prohibited activities in specific circumstances. And some examples are incidental take permits, where, for example, animals are taken or often killed or harmed incidentally to something like fishing, or pollution discharge permits, where you have a facility that will inevitably pollute, but there has been a societal decision to still allow that facility to be constructed and operate. So the first federal law we're going to review today, this is kind of the grand dame of them all, is the Federal Endangered Species Act. We've got the citation up there. It was passed in 1973 by Richard Nixon. It was a successor to the Endangered Species Preservation Act of 1966. Again, these were both responses to widespread public concern about loss of species that really culminated in the 60s. And it provides a program for conserving threatened and endangered animals and plants and their habitats. But what do endangered and threatened mean? So the text of the law says that endangered means any species which is in danger of extinction throughout all or a significant portion of its range. And to be threatened, it's a species which is likely to become an endangered species within the foreseeable future. Right now, the manatee is currently listed as threatened. The manatee was endangered, and it was actually grandfathered into the Endangered Species Act through the Endangered Species Preservation Act. But it was downlisted from endangered in 2017, and this was the result of some litigation brought by Pacific Legal Foundation and others. I should say it was in response to that litigation. And there are two subspecies. There is the Florida manatee and the Antillean manatee, which is in the Caribbean, like Puerto Rico. The Endangered Species Act is implemented by the U.S. Fish and Wildlife Service for manatees. Other agencies will implement it for other species, such as NOAA Fisheries will implement it for whales and fish, other marine species. And the ESA prohibits take of endangered species. There's that word. And the definition, and you'll see language like this show up in a lot of the laws we're going to talk about today, is to harass, harm. I've bolded that one because it's going to come up again later. It's very important. Pursue, hunt, shoot, wound, kill, trap, capture, or collect, or to attempt to engage in any such conduct. And then there are exceptions to this, as mentioned prior. There's a structure for incidental take by permit. And this requires that agency actions are not likely to jeopardize the continued existence of any listed species or result in adverse modification or destruction to designated critical habitat. So essentially, an agency action, it can be a number of things, but oftentimes in my and others' practice, it can be permitted activities such as a construction or an industrial polluting facility. The agency action will be an agency such as the Army Corps of Engineers granting a permit for that activity. So the permanent activity cannot jeopardize an endangered species or their designated critical habitat. But what is critical habitat? And that is habitat that contains features, physical or biological features that are essential to the conservation of the species and which may require special management considerations or protection, and some areas outside occupied at the time upon a determination that these have essential features for the conservation of the species. And for manatees, this was designated in 1976, so only 3 years after the passage of the act, but there has not been a revision except for that proposed in January 2025, and that remains a proposal. It is not final. So it is interesting because things have changed quite a lot since 1976 for manatees and here in Florida between changes in the manatee population and the human population and threats to manatees as a result. The next big federal environmental law that we really should discuss today is the Marine Mammal Protection Act. And similar to the ESA, but a little bit different, it declares things a bit more in the negative. It says, declares that marine mammals should not be permitted to diminish beyond the point which they cease to be a significant functioning element in the ecosystem of which they are a part, and should not be permitted to diminish below their optimum sustainable population. So the MMPA is a very heavily science-leaning and research-leaning statute. And it has a definition for optimal sustainable population, which is the number of animals which will result in the maximum productivity of the population or the species. And there are caveats to that, but that's really the critical language. And that term optimum sustainable population is also going to come up later when we're talking about updates. Similar to the ESA, the MMPA prohibits take of marine mammals, a very similar definition. But there are some exceptions to this. There are incidental take permits. There's a structure for that for institutions like commercial fisheries, and there are exceptions for subsistence hunting and handicrafts for Alaskan natives. And the Marine Mammal Protection Act sets up several frameworks. It sets up frameworks for conservation plans and status reviews, and these have to be done by the best scientific information available. And then stock assessments are for each marine mammal stock that occurs in U.S. waters. That's done every 3 years for most species and every year for certain priority species. And the Marine Mammal Protection Act, again, it's a statute very strongly rooted in science. It establishes the Marine Mammal Commission, which is an independent agency providing independent scientific oversight of agencies addressing impacts on marine mammals and ecosystems. However, I wanted to provide some updates on the commission. In May 2025, the White House budget proposal sought to eliminate the MMC. However, the current draft of the budget for fiscal year 2026 recommends an appropriation of $1 million for the Marine Mammal Commission, and the Senate has recommended $4.5 million, which is consistent with appropriations the last few years. As I'm sure you're all aware from looking at the news, there's a lot of uncertainty with federal government funding right now. So we will see, but it's just to show that all of this interrelates and affects conservation of species as well as all other issues. And the last federal law I'm going to share a little bit about today is the Clean Water Act. I'm not going to spend quite as much time with this one, but it is important because this is really critical to protecting manatee habitat. This is the successor to the Federal Water Pollution Control Act, which was promulgated in 1948, and it regulates the discharges of pollutants into the waters of the United States, and it regulates water quality for surface waters. And generally, this is enforced by EPA, though there are provisions for delegating certain parts of the Clean Water Act to states. This happens in other environmental laws as well, like the Clean Air Act will sometimes have portions of the Clean Air Act delegated to states. So Florida has been delegated enforcement of portions of the Clean Water Act, including NIPD's permitting. That's quite an acronym. I'll break it down on the next slide. But the Clean Water Act protects waters of the United States. So these are not waters that are entirely in one state for the most part. It's navigable waters, territorial seas, and interstate waters, waters between more than one state. Impoundments of these waters of the United States, tributaries and adjacent wetlands, and intrastate lakes and ponds. So that's important because how these water bodies are categorized determines which agencies will regulate them. So the National Pollutant Discharge Elimination System, that's the NIPD's acronym, It makes it unlawful to discharge a pollutant from a point source into navigable waters without a permit. And what is a point source? Is a discrete conveyance. So it's something like a pipe or a conduit. So it's basically something being discharged from a discrete place, whereas non-point sources kind of come from all over the place. It's runoff, precipitation, and that is generally regulated by state agencies, though there were provisions in the 1984 amendments to the Clean Water Act that allow for federal government support from the federal government to states to help with their non-point source pollution regulation. And NPDES permits impose basically there's two sides of it. They're technology-based limitations. So permittees are required to use the best practicable treatment technology. And then there are also water quality-based limitations. So it goes to the standards for the quality of the water body. So there are requirements, I guess, based on what is the state of technology, and also requirements based on what is the state of the water body. And another really important component of the Clean Water Act is the idea of the total maximum daily load. And that is, I'm going to go reverse with my bullets, but it's the total amount of pollution that a water body can receive and still meet water quality standards. And this is applicable to water bodies that are not meeting water quality standards. They're called impaired waters. And the Clean Water Act requires that a pollution cap should be established and a plan should be made. Now we're going to move over to state law. A very important statute for state law is the Florida Manatee Sanctuary Act. This is codified in Florida statutes, and the implementing codes are Chapter 68C-22. I spend a lot of my time looking at those regulations, and it has a very strong mandate, which is that the state of Florida is hereby declared to be a refuge and sanctuary for the manatee, which is the Florida state marine mammal. And very importantly, this designation it's independent. It's not contingent on the manatee being listed as a state or federal listed species. So I broke down the allegory to take. So you'll notice this definition is, I would say, a bit more expansive than the ESA and MMPA. But the act makes it unlawful for any person at any time, by any means or in any manner, or intentionally or negligently, so even if it's by accident, not okay to do or attempt the following: annoy, molest, harass, disturb, injure, harm, capture, collect, pursue, hunt, wound, kill, or possess, literally or constructively, any manatee or any part of a manatee. So this was a stock photo I found online, and that diver better just keep his distance and observe the manatee respectfully. And all of these terms pretty much have regulatory definitions. And I shared the regulatory definition of harassment from the code, and these are some materials from Save the Manatee Club. Harassment means any intentional or negligent act or omission which creates a likelihood of causing injury to a manatee by annoying it to such an extent as to significantly disrupt normal behavioral patterns, which include breeding, feeding, or sheltering. And it also explicitly forbids feeding manatees that are not in captivity unless there is a valid federal or state permit. For example, during the unusual mortality event a few years ago, whereby hundreds of manatees starved to death due to seagrass depletion in the Indian River Lagoon, there was a temporary authorization for state agencies to do supplemental feeding of manatees, but normally that is absolutely not permitted under the Florida Manatee Sanctuary Act. But the disruption side of harassment is really interesting because it basically states that even if you are not directly, going up and, for example, pushing a manatee away from food, if you swim too close to the manatee and it swims away from food as a result, that is harassment under the Florida Manatee Sanctuary Act. Really importantly, the Florida Manatee Sanctuary Act provides for the establishment of manatee protection zones, and these are areas where there is regulated speed and operation, regulations for speed and operation of motorboats to protect manatees. In establishing these, there's a very clearly specified process between the Florida Fish and Wildlife Conservation Commission and the county through which the zone is proposed. There is proposal by FWC, that's the Florida Fish and Wildlife Conservation Commission. A local rule review committee will be established with, by statute, it's a combination of representative of boating, waterways, fishing communities, as well as scientists and environmental advocates. The idea is to get balance of perspectives. And then the rule will go through different levels of review before there will be the manatee protection zone finalized and established. And this also authorizes the Fish and Wildlife Conservation Commission to provide a permitting agency with comments regarding expansion of existing or construction of new marine facilities. So how this will come out, for example, is there will be an application for a permit, such as an environmental resource permit with the Florida Department of Environmental Protection. That would come from something like a marina owner wanting to expand an existing marina or construct a new one. And FWC would then provide FDEP, the agency that will, decide whether or not to issue the permit, with comments to say, we are concerned this will, harm manatees, or this will be fine, this can move forward, or there will be mitigation. There are standard rules for manatee work. But anyway, it's all part of the Florida Manatee Sanctuary Act. And this act required the development of manatee protection plans for specific counties that FWC identified as having a substantial risk for manatee mortality. And the deadline for that was 2006. But these plans will include a lot of items. They'll typically have specific parameters for siting boat facilities. They'll say some areas are too sensitive, some are less sensitive. There will be, assessment of need for new or revised speed zones and provisions for education. And another state level law that we'll discuss a little bit is the Florida Water Resources Act of 1972, another 1970s law, but it's referred to commonly as Chapter 373 in Florida statutes. This establishes 5 water management districts to address water quality and supply. And you can see I have a map of the 5 districts here. And FDEP has general supervisory authority over the water management districts. And there is a permitting program under the Act. There are consumptive use permits, which govern surface and groundwater withdrawals. And applicants for permits have to show a number of things. They have to show that it's a reasonable beneficial use, and that is an archaic term from water law. So just backing up a little bit, before this act was established, Florida basically used common law, riparian right, water, where if you had, water law, where if you had water on your property, that determined your right to withdraw and utilize water. So this did away with the old system and put this in place. So reasonable beneficial use comes from those old paradigms. They have to show that the use is consistent with public interest, which is a very broadly defined. I have seen permits for water bottling of spring water, for example, state that and the economic activity it generates is consistent with public interest and will not interfere with existing use of the resource or minimum flows and levels, which are also, it's another term of law. And the Florida Water Resources Act implements the total maximum daily load program from the Federal Clean Water Act. So this is the implementation of that federal statute. And an important piece of this for manatee conservation in particular are the basin management action plans. And so for different basins, different areas, there will be a framework for water quality restoration that contains different solutions to achieve pollution reductions that are established by the total maximum daily load. Springs BMAPs are really important for manatee habitat, and they contain specific projects and programs to reduce nutrient pollution into springs, which, as I'm sure many of you know, nutrient pollution contributes to algal blooms and kills off seagrass and deteriorate water quality in general. So with the background on those laws, I'm going to share some policy developments that have come out within the last year, two on the Endangered Species Act and one on the Marine Mammal Protection Act. This was a big one. This came out in January, and it was the proposed reclassification of the West Indian manatee. As I noted prior, there hasn't been action taken on this. It came out at the end of the last presidential administration, and the new one has not moved on this further. But this proposal revises manatee critical habitat for the first time since 1976, and it is a result of a 2008 petition from Save the Manatee Club and colleagues, Center for Biological Diversity and Defenders of Wildlife. And this is a big move. It divides the West Indian manatee into its two subspecies for listing purposes. It proposes the Antillean manatee found in the Caribbean for listing as an endangered species, and it keeps the Florida manatee listed as a threatened species with what's called a 4D rule. It's part of the Endangered Species Act, but it would give the Florida manatee the same protections as an endangered species. So even though threatened species typically don't have the same level of protection as endangered species, this proposal would keep those protections in place. And Save the Manatee Club did take action on this. The organization submitted comments supporting and encouraging the proposal, and also encouraging additional areas for critical habitat inclusion based on the best scientific information available. Now, this was another big development in the Endangered Species Act that was proposed in April 2025, so in the earlier months of the current presidential administration, which is rescinding the definition of harm under the Endangered Species Act. And remember, I bolded this in the definition, and the inclusion of harm in the definition of take earlier in the Endangered Species Act. So this is the regulation, and essentially regulations will provide detail or clarify what the text of a statute means. And the regulation for the Endangered Species Act statute says harm in the definition of take means an act which actually kills or injures wildlife, and it includes significant habitat modification or degradation in this definition. And now the Fish and Wildlife Service is proposing to delete this regulatory definition. And Save the Manatee Club submitted comments strongly opposing this proposal due to great concerns about how this will negatively affect the protection of manatee habitat. There we go. And one more proposed policy development, this would be for the Marine Mammal Protection Act. It was proposed in July 2025. It's the Marine Mammal Protection Act Reauthorization Bill. And this is based on a discussion draft from the House Natural Resources Committee. It was introduced by Representative Begich, who's from Alaska. And this would do a lot of things. I couldn't include all of them for a lunch and learn presentation, but one of the greatest concerns, it would change the mandate of the Marine Mammal Protection Act from wanting to achieve optimum sustainable population to continued survival. So really just a rung above extinction, practically speaking. And another critical aspect is it would revise the definition of wanting to, so as I mentioned before, the Marine Mammal Protection Act is a very science-dependent statute, and it would revise the definition of the minimum population estimate to one based on systemic and complete abundance survey data, and that practically does not exist for many marine mammals, and is impossible to obtain, especially thinking about whale species out on the open seas. It's a very burdensome directive. It would exclude the evidence of deaths that aren't directly observed and documented. So this would be big for manatees as well. Watercraft collisions remain the greatest direct man-made cause of manatee mortality. And in calculating data, we wouldn't be able to include evidence of deaths of manatees, for example, that nobody sees are hit, even if it's evident that happened. So that would be very problematic for data collection. It would remove the requirement that incidental take authorizations be limited to small numbers. It would eliminate the requirement that activities have the least practical adverse impact on species. It would automatically approve authorizations for incidental take purposes if agencies fail to meet very tight deadlines, which is also relevant because there have been massive reductions in staff at the agencies. In particular, NOAA does a lot of the Marine Mammal Protection Act work, and they've had a massive reduction in staff. And it would require regulations promulgated under the Marine Mammal Protection Act avoid undue burdens on industry, be the least restrictive means available, and they could be issued only if they are essential to prevent a significant adverse impact on a species or stock. And I don't have a bullet point for this on here, but I will share that this advocating against this reauthorization bill is a very big priority for my work. I've been working with our policy team to meet with folks in Congress to communicate why this would be so harmful. And we're hopeful that it doesn't pass because in its current form, it could do a lot of harm to manatees. And finally, I'm going to share a couple of cases that are ongoing. As I shared in the outline, this one, Save the Manatee Club is a plaintiff, and in the next one, we are not. But we have teamed up with a local landowner in this area. We are challenging, and I have the DOA case number in case anybody wants to go look up the complaint. We are challenging an environmental resource permit for a proposed marina construction in Dumbfounding Bay in Miami-Dade County. And if you look to the right, I have a screenshot of the cover of the the Dade County Manatee Protection Plan, which was written in 1995. And essentially, we and the landowner plaintiff, we allege that the environmental resource permit in its current form, it contains provisions and allows things that are not consistent with the Manatee Protection Plan that was created under the Florida Manatee Sanctuary Act. So I'm sharing this because you can see how these pieces work together. Currently, we're awaiting a hearing. It's before the Department of Administrative Hearings in Florida. So we will see how it goes, but we do feel strongly that the conditions in the permit, and practically speaking, if you look at the complaint, which is public record, you'll see that the permit allows for drafts, which are the MPP requires that there's a 3 feet of clearance between the bottom of structures and vessels, so manatees don't become crushed. It only allows for 2 feet of clearance. It allows for the construction of slips for 100-foot-long vessels in an area that is inconsistent with the MPP. It's too sensitive. So that is that case. And then here is another case that has gotten a lot of press attention. We are not a party to this case. It's Bear Warriors United versus FDEP again. It's currently before the 11th Circuit Court of Appeals, and it's on appeal from the District Court in the Middle District of Florida, Judge Mendoza in Orlando. And the plaintiffs in this case allege that FDEP caused take under the Endangered Species Act by failing to properly regulate water pollution in the Indian River Lagoon, which, as mentioned, caused major algal blooms and seagrass die-offs, which caused the unusual mortality event where many, many manatees starved to death a few years ago. So they actually went in district court under this framework, and it's on appeal. And while we are not a party to this case, we did join a friend of the court and brief. I have a screenshot of the cover of this over on the right to support sound Endangered Species Act interpretation. And that definition of harm under the Endangered Species Act, which is proposed to be rescinded, that comes up a good bit in this case. So again, seeing how everything fits together. So to wrap up, what Save the Manatee Club, is doing for law and policy, and I'm so excited and honored to be here to work on these priorities. We are encouraging passage of laws that facilitate and fund manatee conservation through engagement in the legislative processes. We are taking action against harmful laws and policy, and we really view litigation as a last resort. We're a small organization, but sometimes litigation is necessary to facilitate, our aims for manatee conservation. And something you can do to take action to protect manatees. This is a direct screenshot from our Take Action page, which if you go to the Save the Manatee Club website, it's available on the bar at the top of the page. There is, you can use a form to write to your members of Congress to urge them to defend the Endangered Species Act and the Marine Mammal Protection Act and reject attempts to weaken them like those shared today. And there is also a pledge to restore the Ocklawaha River. While that doesn't directly pertain to an action on the statutes that we discussed today, it's really important because it will signal that you stand with countless Floridians in advocating that the Ocklawaha River be restored. This is a restoration project that could provide abundant natural habitat for manatees, especially as manatees face loss of warm water discharge from power plants as these plants seek to modernize in the next few years. And finally, here's a very silly picture to wrap things up. We've talked about some heavy things today. Let's just say congratulations, you have earned your Juris Doctorate in Manatee Law. Here's a stock photo of a graduate manatee. And thank you so much for joining today. I look forward to hearing any questions that you might have. And I have my email address down here too if you want to ask any questions after the presentation.
Well, thank you so much, Elizabeth, for this awesome presentation. Now we've all earned our, what was it? Now the slide went away, the doctorate in
yes,
in manatee law. So very, very good. Thank you so much. So we do have some questions in the chat already that I'm going to kind of pick out and pass on to you. So the first one is from Rhonda, and she's asking, in the current rule development, U.S. Fish and Wildlife Service is requiring critical habitat be a source of food or within some distance of a source of food. Can they really add that requirement? So I think the question is like, what is the critical habitat? Is it in terms of like, areas where manatees are feeding, that's going to be designated as critical habitat, or like what is, can they be adding that and what is the requirement?
I'm not quite sure I understand the question. Is this an ongoing rule development process? Like, is there a proposal for this?
So I believe this was in, and maybe Rhonda can clarify in the chat. I believe this was in conjunction with the critical habitat designation that came out with the U.S. Fish and Wildlife Service. I know that they, and I'm not, on top of it as much as you are, Elizabeth, but I do know that they decided to designate critical habitat in a certain, parameter of either way a food source or a warm water source. So I don't know if you can talk about that.
Well, relevant to designation of critical habitat is whether the habitat contains features that are essential for the conservation of the species, and access to food is, of course, very, very critical for critical habitat, as we saw with the unusual mortality event where starvation was a big driver of manatee deaths. And I don't know that they're necessarily adding that access to food as a requirement for critical habitat, but I think that is certainly a feature that will weigh in favor of critical habitat being included.
And I believe they kind of put their designation of a critical habitat. They looked at, warm water sources. So it was in a certain mileage away from a warm water source that they were looking at designating that in critical habitat. And also they were looking at areas that had food sources in terms of designating those areas. So hopefully that answered your question. So the next question we have is from Sharon. How does Crystal River ecotourism persist with these laws in place? And I think this was when you were talking specifically about the regulations from the MMPA in terms of harm and in terms of harassment.
I wish I had the citation to exactly where this exists in the law at hand, but I'm happy to pull it. But My understanding is that Crystal River actually has an exemption from applicable law to conduct swim with manatee programs. That's why you don't see these elsewhere in the state. And my understanding, based on just the general dynamics, is there is a very big economic sector with this activity when these laws came to pass. So essentially, they were grandfathered in, but there certainly are issues. And I know Save the Manatee Club is very supportive of companies undertaking best practices and people who participate undertaking best practices to avoid harassment while on these activities. Oh, Cora, you're muted.
Sorry, I'm muted. I just saw that. Thank you so much for that answer. And I think it's also just really important to keep in mind many people don't realize what harassment really means. So, it can be very drastic harassment, which we saw, things like poking a manatee, riding a manatee, doing those kind of things. I mean, I think everyone agrees that that's, very drastic harassment. And harassment can also come in forms where it's just, one person after another, after another, after another approaching a manatee to take a picture, just get a, closer look. And that's in the course of a day or a week or so, it can really cause a lot of stress for them. So that's considered harassment as well, and that's important to keep that in mind. All right, we have another question from Sharon. I believe this was when you were talking about the threatened and endangered status of the manatee. So the question is, why the distinction between the two 4D rule versus classification as an endangered species?
It is funky because practically they function very similar. So the categorization is to suit the definitions of the statute. While there are certainly disagreements to this, but the consensus in the proposal by the Fish and Wildlife Service was that the manatee is no longer in danger of extinction, which is to paraphrase, the definition of an endangered species by the Act, but it is in danger of becoming an endangered species. So essentially, the agency is proposing to keep the threatened species definition because the agency at the time was of the belief that that was more appropriate. But the 4D rule will maintain the protections like the prohibition against take in the Endangered Species Act. So it is a little funky, and I think it's really just to protect perceived integrity of the process. But practically, they function very similarly. And reminding too that manatees are not only protected by ESA, but also the Marine Mammal Protection Act and Florida Manatee Sanctuary Act. So thankfully for manatees, there are layers for protection. And Cora, I don't know if you have anything you want to add to that.
No, that was perfect. You're definitely much more knowledgeable in that area than I am. So thank you for that. So the next question we have is actually a two-part question from Tim. What is the minimum water depth allowed for boats in an existing MPZ? And then what is the depth allowed for boats in an area just outside an existing MPZ, so a manatee protection zone?
I would need to look. So the draft I was referencing with regards to the Thunderbird Marina case, that's the Dumbfounding Bay Marina expansion case. The Miami-Dade Manatee Protection Plan specifically provides for 3 feet of clearance below boats and structures and the bottom to prevent crushing. My recollection is that FWC standard conditions for in-water work for manatees have, I think, even a broader draft. I think it's something like 4 feet. So manatee protection zones typically speak to speed, by my understanding. But Cora, I don't know if you have a different understanding of that.
I think it really depends on the specific manatee protection zones. Like Elizabeth was saying, there are different ones. There are, some that are focused on slow speed, such as idle speed, slow speed, and those designations. They can also include refuges and sanctuaries. So it just really depends on the specific manatee protection zone. It's not necessarily there's one manatee protection zone that applies for like everything. I think it just really depends. So I couldn't answer the question about the water depth for boats, but I think again it depends on, there's several counties that have manatee protection plans or MPPs, and manatee protection zones, as far as I know, are part of that MPP. So whatever is, in there might come into play too. You may have some manatee protection zones in an area where it's very shallow already, and you may have those zones in place, maybe because of seagrass beds. So I would assume that the depth for boats in there would be shallower than, say, in an area where you have an MPC, managed protection zone in place because of, a speed zone. So I don't know if there's a specific depth, like in general, that you can say. If you're talking about the Miami one in particular, then, it probably is, like you were saying, Elizabeth. I think to follow up, there was a follow-up question from Tim on that. Can an MPZ be used to set limits on the design and the size of boats?
MPPs certainly do, as per the litigation for that marina, for example. One of the complaints one of the issues in our petition is that, and I also want to give a quick shout out to our awesome pro bono attorneys, Byron Flagg and Keith Rosardi, who have been carrying the torch on the case. I didn't mention that was filed before I came on staff, and while I've been able to support in some ways, they've really carried the torch on that. So Byron and Keith, if you watch this, thank you so much for your excellent work. But as per that, so the Miami-Dade Protection Plan, for example, does, like you said, core MPZs and MPPs coexist, but MPPs, yes, can restrict the size and design of boats in certain areas because you don't want, for example, massive boats in a very populated or very tight area because of the risk of crushing and collisions that could cause. So those are the sort of things that are taken into account in developing the MPP.
Awesome. Thank you so much for that clarification. We do have a few more questions. I have the next one is from James. Are you concerned about the executive order that would waive any NEPA or NEPA requirements for any commercial space industry expansion? Is it possible to use energy? Sorry, I just lost it. It just jumped off. Is it possible to use energy, sonic, or thermal discharge as a pollutant?
Well, I'm not intimately familiar with that executive order. And when I was putting together my presentation, I did debate including NEPA because it's so important. So for the general group, NEPA is the National Environmental Policy Act, and it's kind of a sweeping mandate on federal agencies that actions taken not harm the natural environment. This was one of the many laws passed. I think this was another 1970s. But it requires agencies to prepare an environmental impact statement and agency actions. So I am not familiar with this executive order, but in general, I'm comfortable saying that I'm not really a fan of anything that waives NEPA requirements for potentially harmful activities.
So thank you. Next question is from Rhonda again. Are you aware of any relevant state legislation coming this session that will affect manatees?
I can speak to some things that have been filed. There is a bill for so auxiliary containers. It's kind of a funky term, but really this bill will seek to prevent preemption. Sorry, and I'm trying to bring this back to plain English because I was at a state or at a county board of county commissioners meeting. I wasn't physically there. I was watching it on live stream. And one of the commenters stood up and he compared wildlife regulations to the Tower of Babel in the Bible, which was a little dramatic. But, as I've been preparing this and thinking about, how much time I spend, metaphorically, not just in the forest with the trees, but like examining different lumps and bumps on the bark and leaves and so zooming out to the forest. So, there are, so obviously plastic pollution is a problem for manatees and other wildlife, ingestion, entanglement. There are a lot of issues, microplastics, a lot of problems, but the state of Florida has laws on the books that prevent local communities from banning certain types of plastic pollution. Some folks probably remember that straws were a very big issue a few years back. But one area that has not been preempted, so preemption is when the state or federal government passes the law that preempts or kind of presupposes the ability of a local government to regulate something. So I just wanted to get there because it's a little bit legalese, but so-called auxiliary containers are one category of plastic pollution that has not been preempted. So there's a bill, it was filed by Senator Garcia, would seek to essentially protect the ability of localities to continue to regulate those sorts of categories of plastics. So Anita, that's one example. Always funding for agencies, in particular funding for FWC and FDEP absolutely affects manatees. It's a really critical because so much of the work, for example, the implementation of the Warm Water Action Plan for manatees, which is to facilitate the orderly transition from thousands of manatees currently relying on power plants for warm water to natural habitat. That's through FWC, and that needs funding as well. Voter education, awareness, there's so much that goes to it. So those are a couple examples off the top of my head. I do think there are going to be some more things coming, but those are just two examples of things happening in the legislative session coming up.
Awesome. Thank you so much for that overview, Elizabeth. I think we have time for 2 more questions here I have in the chat. I'm going to go with Tamara's question first, just because I feel Sharon's is a nice way to wrap it up. So I go with Tamara's one first. She says, I live in Manatee County and Tampa Bay. The Port of Manatee wants to expand its services. How can these layers of protection for manatees rein in the expansion or at least keep the development in line?
So I can't speak to that expansion specifically without better understanding where the expansion is in terms of permitting, in terms of its process. But so I'll speak to just general marine industry issues. So typically there are frequently permits under if there's going to be dredge and fill, that's the Army Corps of Engineers. If there's going to be, construction, it's typically an environmental resource permit under Florida Department of Environmental Protection. And I raise those because both of those processes have opportunities for public comment and engagement and action if something in expansion is illegal. So it's not speaking specifically to Port of Manatee. I don't have knowledge of that particular issue, and I don't think it's proper to provide legal advice in a webinar, but that's just some examples of how the public can get involved in influencing development in their community.
Awesome. And there was a follow-up question. I think I put it in the chat just so anyone can see it. Will SMC share any legislative alerts? I would assume yes, that we do. We always have our action alert team, so you can learn more at savethemanatee.org/action or sign up for our action alerts. I put the URL in the chat as well. I don't know, Liz, if you have any other input. Will we be sharing any legislative alerts?
I think you covered it. Yes, I know that if something comes up where public participation is desired, like the Aqua Baja Pledge, we've had email blasts going up against that. And yes, Save the Manatee will continue to share legislative alerts as they become available.
Awesome. All right. I'm going to go on to the last question. I think it's a nice one to wrap things up for this lunch and learn, since we're almost at 1 o'clock. This question is from Sharon. Elizabeth, could you share your story or thoughts as to why manatee protection is the focus of your work? What is it about manatees that you connected with that fuels this work for you? Motivation is such an interesting and important part of psychology. And advocacy.
So there are 2 parts. I would say there's kind of my early life connection with manatees, as well as my convictions that have developed, throughout my adult life. Early life, I grew up in this area and, until middle and high school. But as a child, I lived in Central Florida, had the opportunity to view and be near manatees in the wild. And, sometimes you just love things for no reason to articulate beyond that you just love them. And I think that's kind of the deeper thing for me is I really do just love manatees. But continuing to, if you look at my bio on the Save the Manatee Club page, you'll see that I've been involved, as Cora said. I volunteered here. I did an internship in college. I did a fundraiser for Save the Manatee Club when I was in high school. I adopted manatees as a child. So it really feels so special and so full circle to be here on staff. But the later life kind of convictions that have kept me going are the realization of the way that wildlife, and in particular species like manatees, are indicators of ecosystem health for people and for life on Earth as a whole, is so critical and important. I've not just worked on wildlife, I've also worked on industrial pollution issues with intersections with human health, and that intersectionality is really important to me. And so I would say just a deep love for manatees and wildlife is, kind of the seed of the passion, but deep convictions beyond the interconnectedness of how protecting manatees really does protect us all, keeps me going on this path. I hope that was clear.
I think so. I mean, I think this was amazing. I did put some more information in the chat to one of the questions, and also if you have any additional questions, obviously you can email Elizabeth directly. She put her email on the presentation earlier. You can also reach us at conservation@savethemanatee.org. So we have a full conservation team consisting of both Elizabeth, Patrick Rose, our executive director, our director of conservation, Dr. Beth Brady, and our manatee biologist, Tiare Friedrich. So between the four of them, they do excellent work. We sometimes split it up into different areas, so none of us have to cover an entire state by ourselves. So there are certain areas that are covered by certain staff members, and they have expertise specifically in those areas. So if you do have any additional questions, or if we couldn't get to your question, you're more than welcome to also email us at conservation@savethemanatee.org, so we can make sure we get back to you. And I think with that, we are 2 minutes to 1 o'clock. So I want to thank all of you for attending. I want to thank Elizabeth for the wonderful presentation and the Q&A, and my coworker Alex, who's in the background but extremely important. She set up this webinar and made sure everything technology-wise is growing great, including our YouTube stream. So thank you very much for your assistance, Alex. And we will be posting this webinar on our website as well, so you can rewatch it or watch it later on if you weren't able to tune in live. So we hope everyone has a great rest of the day. Happy Manatee Awareness Month. And thank you again for attending.
Thank you so much, everyone. And yes, Cora, thank you so much for facilitating. And Alex, thank you so much for making it happen. So really appreciate you all being here and appreciate our shared love for manatees. Happy Manatee Awareness Month.